Good evening, good afternoon, everyone, and welcome to today's webinar, Beyond the Basics, Advanced Licensing Insights for Listed Individuals, UK Sanctions. My name is Shafak Erdem, and I am excited to guide our conversation on this crucial and complex topic. Today, we are fortunate to have Benjamin Wells as our guest speaker. Ben is a solicitor and a specialist in a dispute resolution with extensive experience representing clients in high-stakes arbitration, litigation, and sanctions matters. Ben, could you start by introducing yourself and sharing a bit about your background in sanctions and cross-border dispute resolution?
Of course, Shafak, just want to say thank you so much for having me today and for introducing me. It's very kind of you. It's fantastic to be able to speak to the attendees today about all things sanctions. There's been, as I'm sure you've seen, a lot going on in this sphere internationally, but most certainly in the UK, the US and the EU, which are all jurisdictions that we deal with a lot of the time. Personally, I was involved in one of the first, actually the first sanctions challenge in the United Kingdom, which happened after we left the EU under a new piece of legislation which was set up especially for that purpose. And that case was with regard to a Belarusian IT company, which was challenging its designation because it didn't feel that it was valid. And it actually set the standard of proof for the government to be able to sanction entities. And we've moved on a little bit since then with a number of cases in the High Court and also moving through the Court of Appeal. And there's something, in fact, that's going to be heard soon in the Supreme Court. But as you would have seen, regulations are changing constantly. And that's something that we can notice every day with regard to a broad range of jurisdictions. Working in London as a solicitor advocate, I guess I'm quite lucky in some ways because we have the common law system, we have precedent. So, for example, the case that I was just talking about is a precedent because it sets the standard of proof for sanctions designations. And also due to the Commonwealth, where we have many countries which use the common law as well, they do actually follow our precedents. So we're very lucky in that respect. And through my practice, we actually at Belgravia Law, we have one partner in New York, two in Paris, and the rest are in London, also a King's Counsel barrister within our firm as well. But we really do cover a lot of jurisdictions where we see that our clients run into difficulties. And to be able to cover the kind of US, UK and EU angles, it means we're privy to a lot of these legal developments going on all over the world.
Thank you, Ben. To start, could you give us an overview of the trends you are seeing in sanctions compliance and enforcement, particularly for ultra-high net worth individuals and international businesses?
Yes, most certainly. We're representing a number of ultra-high net worth individuals. What we're really seeing is, I suppose, there's a difference between those who are sanctioned and those who aren't sanctioned. I would like to say immediately that we do represent sanctioned individuals. We really believe that everyone should have a chance to be able to challenge their sanctions designation. And it's not just us. Luckily, it's actually written out in the legislation, in the UK legislation. Under SAMLA, you have the chance to, first of all, be able to challenge administratively. So that's with the minister who has designated a person or company. And if that's unsuccessful, then you can go through the court through what is called a judicial review, where the judge looks at the matter in the round and decides as to whether the minister or the government has made the correct decision or not. But in terms of what's going on recently and trends, I think despite whether people are sanctioned themselves as companies or individuals or private companies, there's a massive trend of compliance, which you were asking about, and specifically a lot of over-compliance. What does that mean? Well, we have a multitude of matters at the moment against US banks and UK banks, all of the big ones. Very often we see a situation where there's a correspondent bank somewhere and a payment made by a private company, which is transferring through multiple jurisdictions. And at some point, one of the banks will say, aha, we believe that this company or person is sanctioned because of the jurisdiction where they're from. And as you know, there are multiple jurisdictions which sanctions are applied to. So it's not just one, but it's many. And at that point, it's very important to be able to engage with those banks to try and unfreeze the funds. If it is a sanctioned individual, then you can also get a license to allow those payments to be made. And we've been very successful in doing so. We've already had around 80 licenses granted to our clients across the board. And this is over a couple of years that we've been procuring these licenses for our clients. If it's a private institution, what we really try to do is engage the financial institution in the first instance. And that can be by drafting a legal opinion. Again, I mentioned where we're operating, and that's really useful because if you have a bank which is subject to both UK and US regulation, then we can get our partners together and we can write the memo together and submit that to the bank, letting them know that, in fact, no, that is a private company and there's no need for them to freeze the funds. That does work quite a lot of the time. You'll be really pleased to know. So I think probably very generally, maybe 50% of the time, that is successful in getting the financial institution to release the funds. And that's also the quickest way that you can do things. Alternatively, if the bank is sticking to its guns, which they do very often due to something we call overcompliance, the reason being is that sanctions carry criminal liability. And the people in the administrative kind of finance departments of banks are very worried about that. And you can completely understand why they would be. In those instances, we do go out and get the license for the clients, and then that enables the monies to be unfrozen. But I think that is one of the major issues with financial institutions and sanctions at the moment.
Ben, you have handled many complex license applications in coordination with entities like the OFC and the Foreign Commonwealth Development Office, FCDO. In your experience, what are the most challenging aspects of this process, and how do you recommend addressing these complexities?
It's a very good question, and it's really about strategy. We find that a lot of the transactions that we're working on, or disputes, there can be multiple jurisdictions involved. And when I'm saying multiple, it can be 4, 5, 6, 7. We have a lot of matters which involve funds in, for example, I don't know, the Cayman Islands or the BVI. And in fact, monies are held by multiple institutions. And that's where all of these different jurisdictions get drawn in. So you really have to consider, before you make your license application, the most important question is, which regulator are you making the application to? Now, it's obviously very simple for us. If it's OFC or OFAC, it's really easy to do. But at the same time, you need to think about how long those processes are going to take. And those timeframes have changed significantly in the last couple of years, especially with OFC taking on a lot more employees to be able to deal with the inquiries very quickly, which is fantastic. And you need to think about, if you're to make 2 applications at the same time, very often you make your OFC application and the OFAC one, and OFAC will say to you, well, how's the other application coming along? Because if there's still a lot of time to go for the other regulator, they might think, well, we don't need to prioritize this application because they've got a lot of time to wait in the other jurisdiction. So sometimes it can actually be better to, if you've got experience of knowing which regulators deal as quickly as possible with the applications, to actually get one application agreed and approved. And we've done that previously. We've got a client who had an application granted in Switzerland. And that application sets out the full history about the client, about the structure, and it said this client isn't subject in our eyes to sanctions in any way. And that's absolutely fantastic, because then you can take that already granted license application and take it to other jurisdictions, say, look, this is what the Swiss regulator has decided. We believe the same, and obviously put together a lot of submissions as to why that is the correct case. And sometimes off the back of a positive decision in your favor, then you can actually get other licenses granted much more quickly. So there's a lot to be thought about in the strategy when things go multi-jurisdiction, which they do very often.
Yeah, I want to ask another question about your recent work with PL Germany GmbH. Could you share insights on handling judicial reviews in sanction cases? What were the key legal considerations in that case, and how might they apply to other sanctions-related cases?
Yes, of course. So this was one of the first cases after the situation in February 2022. We were representing PL Germany, which is actually, it's an English company, but it's a subsidiary, I mean, many subsidiaries down of a parent company, and there was a sanctions element. So I believe that the company was around 20% owned with a sanctioned percentage in there. And at the time, our client was making screens for gadgets, and no one would interact with them. So not their suppliers, not their customers, to the extent that they were worried that there would be sanctions repercussions for them. This got very bad for the company, and as a UK company, it had about 30 employees. It got to the stage where the company was not going to be able to continue and was going to go bankrupt, and all of those people working in the UK to be laid off. So it was a rather sad situation. And we had made an application on behalf of the client to OFSI, but they were very overworked at the time. I can only imagine how many thousands of applications they were receiving per day. And unfortunately, they were unable to respond to that application. So instead, what we did is we went to the judge and we got an expedited hearing. We requested judicial review, not of the actual decision that OFSI had made, because it hadn't made one, but of the lack of a decision, which is also something that you can review through the courts. And we were really lucky that the judge found in our client's favour, saying that OFSI had to make a decision within 10 days. And in fact, within 2 days, we had a declaration setting out that our client was not sanctioned at all, which was fantastic. It meant they could continue trading and that they didn't go bankrupt. And we believe that became precedent under English law as well. So it's a case that you can refer to in future situations. But really, it was very good because we engaged with OFSI really well. They now obviously know our names, and we do have a really good working relationship with them. So when we do put in our license applications, and we've got many on the go at any one time, generally, and having taken on a lot more staff, they are extremely responsive. So that's fantastic in terms of how things have moved along since that case was in the court.
Yeah, it's an amazing work, actually. And my next question is about the sanctions compliance. And as we all know, it intersects with many intricate financial and legal issues. In your work with large financial institutions, what are some common challenges you encounter in adhering to both UK and US sanctions requirements?
I suppose one of the difficult things is that sanctions regulations are changing so quickly. There have been quite a few new regulations, even just in the last month. So, for example, the authorities now have a disqualification power over directors of companies. So they can go ahead, and if someone is sanctioned, they can disqualify them as being a director of UK companies. For example, in the last couple of months, there were Belarusian sanctions, which were expanded to cover all aluminium produced in Belarus. And there have been similar regulations for diamonds and other natural resources within the last years as well. And the general licenses, which allow certain payments to be made without any kind of trouble, you can just refer back to the general license. Those are being expanded and amended all the time, so that, just an example of a recent one, it allows sanctioned people or persons to pay water companies out of their frozen bank accounts in the UK. And then, for example, the UK sanctioned 5 ships and 2 entities involved in LNG, so that's liquefied natural gas, really recently. And that's the first time the UK has used its new ship specification power to directly target those vessels. And in fact, I'm in court today, hopping in and out of court on a similar case with regards to shipping and delivery of goods, which has a sanctions element, and actually that has a US sanctions element to that case. It's the same with OFAC. They're developing all the time. And also in the UK, we've now implemented FAQs, so it's frequently answered questions. And those can be absolutely invaluable for private companies to read through to see what the usual situation is or what the likely answer would be. And it does cover a lot of queries with regard to financial transfers and other issues, which can be extremely helpful. But I think to answer your question very quickly, Shafak, it's just staying on top of all of those developments is possibly the most difficult parts.
Yeah, I fully agree with you. And for clients aiming to challenge or review their UK sanctions designations, what strategies have you found most effective, especially when preparing requests under the Sanctions and Anti-Money Laundering Act? SAMLA?
So it does depend which jurisdiction you're in. We're very lucky that we had a client who was delisted in the US very recently. And so I'll speak about the US a little bit first because they're a little bit more advanced in terms of the way that they deal with those delisting applications. In the US, it's really possible to engage with OFAC. So I was in Washington at the end of last year, and you can actually go and meet with OFAC and you can discuss your client's case, which is really refreshing because you sit down and you engage with them and you say, right, what are the purpose of sanctions? Well, it's to stop people contributing to a particular country or helping them, or to disencourage people from doing acts which would be of a similar nature. And in fact, it was possible to agree with OFAC that our client would do certain things, divest himself of something or stop being active in particular businesses, upon which he would be delisted. And we were very lucky, the client's very lucky that he was delisted in that jurisdiction. So I think those are some of the tips and tricks for the US. It's all about engaging. It's about seeing how you can distance yourself from whichever regime it is that your sanctions have been tied to, and how you can really show that you do not want to be related to that or supporting that regime in any way at all. In the UK, it's very similar. It's just the process and how you go about doing that is slightly different. And in fact, it's a two-tier process in the UK. So first of all, you have your administrative review. And in the UK, that's by far the best way to get delisted. And there have been, I mean, more than several, maybe 4 or 5 delistings. We see that the best way to delist is on a factual basis. So if there's a mistake in your designation, that's really positive. Obviously, it's extremely unfair to the person who has been sanctioned, but there's an element of collateral damage with the sanctions anyway, because it's drawn with a really broad brush to try and catch as many people as possible to potentially fall foul of sanctions, so that the government can take those actions to try and, not to encourage people to do anything that would otherwise contraband sanctions in any way. And we've seen if there's, for example, an individual who has been said to be a director of a particular bank or institution, but in fact, on the date that they were sanctioned, they were not in that position, i.e. they had already resigned. It could be 6 months ago before they were designated, or it could be up to a couple of years. Then the chances of getting delisted are much higher. And we always look to make those arguments at the administrative level and to put as much stress on the person's background, what their hopes and beliefs are, how they're engaging to either distance themselves or go into other lines of business that aren't related to the country where they've been sanctioned with regard to. That can be really helpful. But also there's a couple of other things that it's possible to do. We have seen people renouncing, for example, their citizenship of a certain country to show that they've really distanced themselves, moving away from that place to another place completely, along with their families. And another couple of things that they can do is resigning from particular posts. So when it says Mr. A was director of X bank, well, he's no longer a director of that bank because he's looking to distance himself and not to help the regime, which they're saying that he is in any way. So I think those are the best points. Once you get to the legislative, the judicial review stage, it's a lot more difficult, because if the government, or it's the FCDO, so it's the Foreign Commonwealth Development Office that reviews these delisting applications, if they've not delisted you at the administrative level, it means they're putting up a stand, and it's going to be a lot more difficult to get delisted once you go to court.
This is quite wonderful what you shared with us today. My last question is, as a fellow of the Chartered Institute of Arbitrators and an experienced arbitrator, how do you see arbitration playing a role in resolving disputes related to sanctions compliance and enforcement? And what should professionals keep in mind when considering arbitration in this context?
Shafak, the arbitration and sanctions is absolutely massive. We've seen so many matters which are in arbitration, being arbitrated with a sanctions element to them. If I may, it's pretty much our forte. So we have multiple corporate clients who may or may not be subject to sanctions, but you get a party on the other side, which if they're not subject to sanctions is saying, we don't believe we can engage with that party because of sanctions. Now, in fact, those clients' positions are very, very strong because it's quite easy for us to take the company name. We go onto the list for the US or for France or wherever it may be. We type in the name and they're not coming up. So clearly they're not subject to sanctions. However, there are a lot of arguments where a company has backed out of their contracts with, for example, a party from Russia or Belarus or Venezuela or wherever it may be, that they can make a lot of arguments about sanctions regulations and export controls. So there are multiple facets to these matters. They're extremely interesting, and we've seen them across multiple arbitral institutions. So we're working on ICC arbitrations, LMAA, all of the different kinds of arbitrations that you can think of, really. And there are a lot of applications off the back of these arbitrations that then go into the courts as well, if you are applying for interim relief with regard to that arbitration. So in short, it's playing a really big role because arbitrators are involved in analysing all of these cases and seeing whether there really is a sanctions element to them, or in fact, it's just one of the parties by choice has pulled out of that agreement, in which case they're liable to pay damages to the other side in accordance with the contracts that they signed.
I got it. And thank you so much for your insights and expertise today. We have covered a broad range of topics from recent trends in sanctions enforcement to effective strategies for compliance, judicial review, and arbitration. And thank you to everyone who joined us. We hope this session has provided you with actionable insights and a clearer understanding of how to navigate the complexities of UK sanctions and the licensing. Please do not hesitate to reach out if you have any additional questions or would like to know more about this complex world. Thanks again and have a great day.
Thank you, everyone. Thank you so much for joining and taking the time. It was lovely to get the chance to talk about sanctions.
Thank you.